All right, so good afternoon, everybody. Apologies for the the challenges getting started. It's my second time using this platform, and it's still causing me some trouble, but I think we're okay here and ready to go. Hopefully, everyone can see my slides okay. Jesse, if you don't mind letting me know if they can't, please do let me know, and I'll see if I can figure it all out. So thank you to all of you who are on with me this afternoon. We're able to join and participate in this webinar. And thank you as well to the Canadian Virtual HR Conference and TorontoJobs.ca for having me here today. I've spoken at a number of Toronto Jobs events, and they're always great events with great turnout, and I always have great questions. No pressure for any of you here, but if you're able to provide questions as we go through, I find that really does help me provide a lot of value to everybody who's participating today. The real life scenarios are really where the value can come from. I could speak to many different real life scenarios I've been speaking to clients about recently, but if I can speak about one that is relevant to one of you, it's probably relevant to many of you, and it will be helpful. So first of all, just to let you know who I am. So my name is Joel Smith, as I'm sure you all know by now, and I'm a management side labor and employment lawyer at Williams HR Law. We're based in Markham, Ontario, just at the 407 and the 404. So we're a boutique labor and employment law firm. And what I do is really all aspects of labor and employment law. Right now, in the context of this pandemic, what that often means is litigating wrongful dismissal lawsuits and dealing with layoff type issues with clients, especially because of so many clients of mine, unfortunately, have had to let people go and lay people off and deal with the challenges that come with that. I'm also, of course, supporting my clients through the various issues that they're dealing with from an HR law perspective right now. Clients generally being the HR people or the company owners at my clients, depending on the client. But in most cases, they are going to be HR people just like you. And what I do, I advise on all aspects. Again, lately, that's going to be a lot of accommodation issues, a lot of health and safety issues, a lot of termination and layoff issues, but so much more as well within the labor and employment law landscape I practice across the entire area. So why are we all here today? Why are you here watching this presentation? I'm sure it's because you are dealing with these issues just like everybody else is right now. Everything has changed so dramatically. And what's so great for HR people, because it's hard to see the good in all the things we've been dealing with these last few months, but what's so great for HR people is that you do have the opportunity right now to really make sure that you're at the table with the decision makers of your organizations and make sure that the right things are put in place. Because right now, HR is as important as anybody else in the organizations, given the different issues that you're dealing with, given the workforce challenges that you're all surely facing as you go through this process, no matter what industry you're in, no matter the size of your company, no matter what type of work you do. And so just to jump ahead here, knowing that we only have about half an hour, I'd like to bring us forward. Hopefully this is going to work here. And this is me when I'm not working from home and doing a presentation from here for you, in case you're wondering. So what I want to discuss today are really just hotspots that people in HR are facing right now. Again, I'm sure you're all dealing with these. And what I really want to focus on, given the limited time that I have to speak to you today, are health and safety requirements, accommodation, and specifically accommodation of family status and disability, and layoffs and terminations. And there are so many different parts of those that you're all dealing with right now. But I want to just highlight a little bit of what I want to speak about here. So from a health and safety perspective, obviously dealing with people who feel like it's not safe to be at work, trying to protect your workers from contracting COVID-19 is the big hot topic right now. And really, if you're an Ontario-based employer, as I'm sure most of you are, that comes down to your Occupational Health and Safety Act obligations to ensure that you're taking every reasonable precaution in the circumstances to protect your workers. But right now, it's so much more than that. And what's entailed with taking those reasonable precautions is more and different than it really has ever been before, certainly since the Occupational Health and Safety Act in Ontario has been in effect. And that's because, some of you may be in workplaces where you don't really have much in the way of health and safety concerns on a day-to-day basis. You may not even have WSIB coverage if you're one of the exempt industries because of the general level of safety in your industry. Perhaps if you work in an office, you don't really face that many safety issues day-to-day in most times. We're not in most times, obviously, anymore. Now we're in this pandemic world where you need to make sure you're protecting your workforce from health and safety issues, and taking steps to look into and investigate if there are any health and safety related complaints to ensure that you're meeting your obligations. So I want to talk about that a little bit today. In addition to that, I want to talk about accommodation issues for you as well. And from an accommodation perspective, there are all sorts of things to really talk about. But again, I want to focus on family status and disability accommodation. From a family status perspective, the big issue that I'm seeing with clients, and I'm talking to clients just about every day about these days, is back to school, and in other cases, back to daycare, and the issues that come with that. So many employees are saying that they can't return to a physical workplace right now. And so many more are saying they can't work at all because their kids don't have care right now. Their daycares are closed, or their daycares are unsafe. The schools are just reopening, but they're not fully live, so they're in part virtual. Or the employees are saying that they're not comfortable sending their kids back because they're just not so sure that school is safe. They've been seeing how all the school boards have been struggling to get things going and make sure that they're ready to go. I know just this week, the Toronto District School Board had their contact tracing app crash on the first day, causing total mayhem across the school board. So that's just one example. That's the kind of thing people are dealing with right now, and something that you want to make sure that you're understanding, and you understand what your obligations are when it comes to accommodating employees in those cases. And in addition to that, ensuring that you understand your obligations to provide job-protected leaves to your employees as well. That's especially the case because, as I'm sure many of you know, again, just to focus on Ontario here, the infectious disease emergency leave under the Ontario Employment Standards Act that was created really in response to COVID-19 allows employees to be off work if they have to provide care or support to their children or certain other family members for reasons related to COVID-19. And that sounds pretty broad, and that's exactly how the government is interpreting it. They're interpreting it broadly. The way the government interprets that language and that leave is that any employee who chooses not to send their children back to daycare or school because they're just not comfortable doing so in light of the pandemic, they're going to be entitled to a job protected leave right now. And that's an indefinite leave that they can take as long as COVID-19 is designated as an infectious disease in Ontario. And I don't see that changing anytime soon, if ever. And as long as the circumstances giving rise to the leave continue. So as long as they continue to be uncomfortable sending their kids back to school because of COVID-19 and therefore can't work, they're entitled to that leave. And so that's another big one. And that really fits hand in hand with your accommodation obligations when it comes to family status when you're facing those issues. Now, in addition to that, what I really want to make sure we talk about today as well is disability accommodation. That's both physical disability accommodation. The most obvious cases right now are where an employee contracts or suspects they may have contracted COVID-19, and they're going to be generally entitled to be accommodated generally by being off work while they're potentially going to be spreading the virus. But also from the mental health perspective as well. Everybody is anxious. Everybody's mental health is, just about everybody's mental health is at a tougher spot than it really has been before the pandemic, because this is a challenging time for everyone. Challenging from an employment perspective, challenging from an economic perspective, challenging because people are scared that they or their family members or their elderly family members, worse yet, might contract COVID-19 and what might happen if that does happen. And so with that, people need accommodation for their mental health disabilities more than ever. And many people who didn't really have mental health issues that rose to the level of a disability under the Human Rights Code now may have a disability that entitles them to accommodation because of it. And so that's another thing you really need to keep an eye out for as we deal with what a lot of experts are calling the echo pandemic, the mental health pandemic that arises from this physical health pandemic that we're dealing with. The last section I want to talk about is terminations and layoffs. So first of all, from a layoff perspective, again, I'm going to focus on Ontario here, given that I understand that most of you will be from Ontario, if not everyone here. And so when it comes to layoffs in Ontario, there's a general rule that has existed for many, many years, since long before the pandemic, that an employer can only temporarily lay off an employee if they have the right to do that in the employment contract. Generally, that's an express clause right there in the contract that says the employer can lay the employee off in the way they're allowed to under the Employment Standards Act of Ontario. That general rule may still be in effect right now. I say may because there is a lot of dispute in the employment law bar right now amongst others who do what I do about whether that law has changed because of some temporary legal changes that the government has made. Right now, we don't know with certainty whether that law has changed, but there is certainly at minimum a good chance that if you're an employer and you don't have the right to lay your employees off temporarily in their employment contracts, but you've laid them off nevertheless because you just had to as a result of the pandemic, you are facing a risk that the employee could claim that you don't have the right to do that. And as a result, you've constructively dismissed them, which effectively means you fired them and they're entitled to whatever their termination entitlements are at law, as though you had told them, we have to let you go without cause. Now, another big piece of layoffs right now that I'm sure many of you are live to is really how the layoff rules have changed temporarily in Ontario. So as many of you may recall, back in around March, a lot of companies had to temporarily lay people off, and they were trying to pay attention to how long they could lay people off under the Employment Standards Act. The ESA, the Employment Standards Act, allows employers to lay employees off for up to 13 weeks in any 20-week period, or if they continue the employee's benefits or provide other forms of compensation laid out in the ESA, they could lay them off for up to 35 weeks in any 52-week period. So 13 weeks or 35 weeks, generally depending on whether benefits are continued during the temporary layoff. Those are the maximums in the ESA. And so after a lot of employers laid people off back in March, a lot were really watching that 13-week clock. As the months ticked by, the weeks ticked by, they were getting closer to 13 weeks of layoff. They were worried because what happens at the end of those 13 or 35 weeks, if the employee is not called back, they're deemed to have been fired by the employer. Similar to that constructive dismissal concept I just mentioned. And as a result, they're going to be entitled to whatever their termination entitlements are at law. And so employers were facing that down, wondering what was going to happen, not sure how they could bring people back to work. And then right at the end of May, the provincial government passed a regulation called the Infectious Disease Emergency Leave Regulation that changed the rules around layoffs. Essentially what it did, among a whole bunch of other things I won't take the time to get into right now, is it deemed anybody who had been temporarily laid off back to March 1st, retroactively to March 1st, to be on an infectious disease emergency leave, similar to that leave I was just talking about, the same type. And so as a result, the layoff clock, the layoff rules that generally apply didn't apply because as far as the ESA was concerned, they weren't laid off anymore. They were on a deemed leave. And originally, when this law was passed back in the end of May, this regulation was passed at the end of May, these temporary rules were supposed to be in effect until 6 weeks after the declaration of emergency in Ontario ended. Many of you may recall just a few weeks ago, toward the end of July, I believe it was July 24th, the declaration of emergency did end. And so then 6 weeks after that, we were all watching this clock. September 4th, that was when these temporary rules around layoffs and deemed leaves were going to end. And what we were looking to see at that point was after September 4th, then the layoff clock would start ticking. And so the 13 or the 35 weeks would start being counted from essentially September 5th. We were all waiting for that. A lot of employers were wondering how we're going to do this. Now we've got the clock ticking again. But then the evening of September 3rd, right at the last minute, the government intervened again, and the provincial government amended that regulation that I was talking about to say that those layoffs are now deemed leaves all the way up until January 2nd of 2021. So they added a few more months, about 4 months, to these temporary rules. And again, what that means is, according to the ESA, the 13 or 35 week maximum layoff durations won't start ticking until January 3rd, unless they change the law again. We don't know. And the way they've been doing things recently, trying to keep up as things are changing so quickly, we probably wouldn't see any change until, right around the holidays. But as it stands right now, January 3rd is when those clocks will start ticking again. And so that's a really important thing. I wanted to lay that groundwork because it's relevant to some of the other things I want to talk about a little bit later here as well. On top of that, I want to again talk about terminations here this afternoon. And really what I want to focus on when it comes to terminations is the impact of a recent Court of Appeal decision on employment contract termination clauses. I won't get into it in detail, again, because of the time that I have here. But as some of you may know, employment contracts can contain termination clauses. And those are intended to limit how much an employee is going to get if their employment is terminated by the employer without cause, which is most terminations. And certainly just about all restructuring terminations will be without cause. And so there are two different termination entitlements that apply generally. There's the Employment Standards Act minimum termination entitlements. Those can be up to 8 weeks of notice or termination pay. And then for larger employers and longer service employees, up to another 6 months of severance pay, depending on how long the employee has been working. So maximum 8 months under the Employment Standards Act. But in addition to that, there's the common law reasonable notice standard, which provides for those who don't have enforceable termination clauses quite a bit more notice entitlement to employees, up to 24 months for longer service or senior or older employees. It's that common law notice standard that these termination clauses are intended to contract out of, so that the employer can provide as little as those minimum Employment Standards Act entitlements, which is far less in just about every case. Employers have been relying on these clauses for a long time. The courts have been changing the rules on when these clauses will be enforceable year after year for about a decade now. But we recently saw maybe the biggest one of these decisions we've seen in the last decade from the Court of Appeal, where essentially, I'm not going to get into detail of what they did, but what they did means that the vast majority of termination clauses that are in effect in Ontario right now, that are currently in employment contracts for Ontario employees, are no longer going to be enforceable. And as a result, all these employees that employers thought they could let go at a more limited amount of notice aren't going to be able to let them go for that amount any longer. Instead, those employees are going to be entitled to the common law notice standard, unless employers take steps to revise those employment contracts, get the employees to agree to new contracts, meet the legal requirements that are necessary to do that, because it's a bit tricky too, but it's doable with existing employees, to ensure that you're protected going forward. And it's so important right now because, well, one, this change just happened at the end of June during the pandemic. But secondly, and really importantly, terminations are just more common right now than they have been in such a long time, certainly since the 2008 recession, and I would say since long before that as well. And so employers really do need to be protected, and they need to be alive to this concern that you may not be protected as you thought you were before. Okay, so I'm going to dive in and really talk about these hotspots in a little bit more detail now that I've set that groundwork for everyone. What I would ask, if you do have questions about the content I'm discussing, please put them right there in the chat box, which I think should be on the right side of your screen if yours looks like mine. And I'd be happy to speak to those. Now, before I get into the hotspots, I'm sorry, I just wanted to make this note. Given I don't have that much time here today, I want to just draw your attention to our COVID-19 Resource Center. So my firm has a COVID-19 Resource Center that we've been maintaining and regularly updating throughout the pandemic that really provides a lot of analysis and discussion about all the different HR law implications of this pandemic, so much more than I have time to talk about here today. And that's going to provide a lot of detail for you, a lot more information if you want more information about what I'm talking about here today, or other related issues as well. So I invite you to go there. It can be accessed from our website, williamshrlaw.com. And again, you can get a lot of really helpful value from that. On top of that, we just hot off the press yesterday digitally published in this case, given we're in a pandemic, our newest newsletter. So it's our firm's fall 2020 newsletter. And our newsletter this year is focused on case studies. So the title is Return to Work Case Studies from the Front Lines. And what that includes is 10 different scenarios that we've taken from real life scenarios we've been supporting our clients with, and that we know many other clients, many other employers are dealing with right now. And we go through the steps that were taken, what actually happened, and what steps were taken to protect those employers from the liability they could have faced, as well as addressing what that liability is and why there are risks for those employers in those cases. It's a hefty read. It's about 32 pages. Of really detailed information throughout those 10 articles, but we have really good content in there. And I invite you to download that. You can do that from our website as well, to ensure that you understand these issues, again, more than I'm going to have time to talk you through today in the next few minutes. So let's get to the hotspots. First that I want to speak about is health and safety. This is one. It was really the hottest, the biggest issue at the start of the pandemic that employers were facing, that I'm sure all of you as HR people were thinking about initially. And when you think about health and safety, again, you're thinking about protecting your workers. The initial thing that a lot of employers thought was, well, PPE, right? Let's get PPE, let's get face masks, let's get face shields, let's get gloves, let's get sanitizer, and that should be good enough. And I'm here to tell you, unfortunately, that's not going to be good enough. That may well end up being a big part of the measures you take to protect your employees. And I'm sure many of you are already doing that and providing those different types of PPE to your people. But before you even get to that point, really what you should be doing, and if you haven't done it yet, you should go back and do it now, is really doing a risk assessment of what the safety issues are at your workplace specifically, and where these different issues might arise. So look at where employees might have to get close together and therefore have a risk of contracting COVID-19 from one another. Look at surfaces that are commonly touched. Look at the way that work is performed when employees have to go out into public and see other people and be near other people where, of course, they might contract COVID-19. That's a particular risk in the past few days, and I'm sure, unfortunately, the next little while as well, as the numbers have just skyrocketed in Ontario and across much of the rest of the country, especially obviously in these hotspots of Toronto, Ottawa, and Peel region, where many of you may have seen that the Ford government is announcing today, may have already announced at this point, that the gathering limits are going to be much smaller than they were before. Now it's going to be 10 people indoors. Businesses are excluded, so your workplaces would be excluded, but 10 people indoors and 25 outdoors to try to stop these big numbers and the spread that we're seeing right now. So, that's something you want to be mindful of, as well as really just ensuring you're protecting your people day to day and that you're assessing those specific risks that you have in your workplace. What you want to do, a quick point before I move on here in the interest of time, is when you are trying to protect your people, keep in mind that under the Occupational Health and Safety Act in Ontario and really in other jurisdictions across the country as well that have, very similar rules to what I'm talking about here in Ontario, employees and managers have their own obligations as well. And when it comes to managers, they actually can have their own liability if they're not protecting employees' health and safety. So what you really want to do, and what's really been beneficial for a lot of my clients that I've spoken to about this, is you want to make sure that you're foisting these health and safety obligations on your employees as well. Don't take it all on as an employer at the high level, at the HR level, at the executive level. You want to make sure that everybody understands that they all have to buy in and they have to work together. It's the same idea that we've been, so many people have been talking about since the beginning of the pandemic. We all are in this together. Let's try to beat this together. It's on a smaller scale. Within your workplace, the same idea applies, and you should ensure that your employees understand they do have obligations themselves so that they help to protect themselves and each other as well. So let me shift to accommodation. And this is probably right now in these last few weeks and the next few weeks going forward, the biggest hotspot that employers are facing. And I want to camp on this for a few minutes, knowing I don't have too much more time to talk to you here this afternoon. As employers, you have a duty to accommodate your employees all the way up to the point of undue hardship. That's the case regardless of where in Canada you're located and where in Canada your employees are located. What that means is you need to meet your procedural duty to determine what types of accommodations you might be able to provide when you become aware that an employee may need accommodation, either because they ask you or because you simply become aware or suspect that they may need it based on some circumstances that have come to your attention, whether it's because the employee is acting differently and you think they might have mental health accommodation needs, whether it's because you see them showing up to work late day after day, calling in sick day after day and mentioning that they're caring for their kids and they're struggling to keep up. Whatever the case may be, you need to inquire and provide that accommodation. And so that procedural step is to figure out what accommodations may be feasible for you. So how can you provide reasonable accommodations, which is your standard that you need to meet as an employer, to your staff that also ensures that they're meeting the fundamental requirements of their role. So they're still providing some value to you, because that's another important part of the accommodation process. Once you go through that procedural accommodation step, you need to meet your substantive accommodation obligation. Really, that just means actually providing those reasonable accommodations to your employees after you've assessed and determined what you can do as an employer. And so what so many employers, I touched on this before, what so many employers are struggling with right now is when employees are going to be entitled to leaves under the Employment Standards Act and how that interacts with your obligations under the Human Rights Code or whatever human rights legislation applies to you depending on your jurisdiction in the country. So we're seeing accommodation needs arising in so many different circumstances right now, where, again, employees don't have daycare at all or full day daycare available anymore because of COVID-19 related reasons. And again, in most cases, they're going to be entitled to employment standards leave for that, as well as family status accommodation in some way. Employees who may have full day school available for their kids, but again, they opted out. They thought, you know what, I'm worried about this. I can't imagine that there's not going to be spread in schools. And of course, we're already starting to see outbreaks. And so I expect we'll see more and more employees who may have opted in the first place now start opting out because of those concerns. But they opt out. And in some cases, they're actually stuck with that decision for some time. So many of the school boards across Ontario and to my knowledge, across the rest of the country as well, set some rules, set opt-in dates, sometime usually in August, so they've all passed for the initial date by now, for whether employees are going to send their kids back to school live or whether they prefer virtual learning or what. And in many of those cases, after those opt-in dates, after the parents opt in or opt out, they're stuck with that decision until certain trigger dates throughout the school year. And many of them don't come for a couple of months, a few months, end of a semester, what have you, before the parents can trigger and change their decision to opt in and send their kids to live school when they may not have done that initially. And why that matters right now for you as employers is if your employees have opted out, they can't send their kids to school right now because they've opted out and they're stuck with that decision for a while. You likely will have an accommodation obligation if they're not able to meet their requirements at work because their kids are at home and they have some sort of caregiving obligation that doesn't allow them to meet their usual duties. And that may involve working from home, if that's possible for the type of work that you do and that they do specifically, or it may involve allowing them to be off work, usually unpaid, depending on whatever sick and other personal entitlements and paid days you provide, but still off work with their job being protected until they're able to return. There's also, again, just employees who are just strictly fearful about sending their kids back to school or daycare or just generally being out in public. Employees themselves, again, may have those mental health issues that I was talking about before, that are aggravated about themselves by fear of themselves contracting COVID-19 or their kids or family members contracting COVID-19. There's also physical accommodation issues where people actually get COVID-19, but also if they may have some sort of immunocompromised or other health issue that puts them at greater risk if they were to contract COVID-19, they may be entitled to some sort of accommodation. And same thing if they have kids who they can't send to school and can't provide use their usual care, whatever that may be, daycare, babysitters, school, because of those children's health concerns, they may be entitled to accommodation there as well. We're also seeing a lot of requests where employees say they're living with elderly family members and they're just too afraid to go out into public and come back and maybe contract COVID-19 and pass it on to these elderly family members who, of course, are at greater risk if they were to contract COVID-19. And again, so many more. These accommodation issues are so significant for you. We talk about a number of these in that newsletter that I was talking about before that you can download from our website. And I invite you to go and really get a better handle on what those obligations entail from that newsletter and from our resource center. But suffice to say, it's challenging. And if you're not sure how to deal with these things, if you haven't dealt with these issues at length before, you really should understand that accommodation is a minefield for employers, and it can create so much liability for you as an organization and for your managers specifically if accommodation is not provided in the way that it's required to be provided under the law. Right? Some of those issues you can face. Reprisal is one big one that you may face, where if you treat people differently, if you punish people because they're not working, but the reason they couldn't work is an accommodation issue, you've got big exposures there. You can face specific exposures for discrimination or for failure to accommodate. And you need to make sure that you're just keeping all of that in mind. Right now, I know I'm just getting to the end of my time here. I've been keeping an eye on the chat and haven't seen questions come in. I will stick around if the program lets me. I think it will, just to answer any questions that may pop in. And Jesse, or Alex, let me know if that's not the case, if that's not doable here. But really quickly, before we get to the end here, I just want to quickly touch on the layoff and termination entitlements. I spoke at some length at the beginning here about layoffs, so I think I was clear there. When it comes to layoffs, what you want to keep in mind is you do have more time under the Employment Standards Act if you're Ontario than you usually would. Really, you have until end of March, beginning of April at minimum, according to the Employment Standards Act, but you may still have those constructive dismissal exposures as an employer. And when it comes to terminations, keep in mind your termination clauses that you may have been relying on may no longer be enforceable, and you may be looking at 6, 8, 12, up to 24, and sometimes even more than that in unique cases, months. So up to 2+ years of notice or pay in lieu of notice if you let your people go and you don't have those enforceable termination clauses. And keep in mind that the common law notice entitlements that I'm talking about there, those big numbers of months, those are actually bigger for people who are let go right now than they are in other times, because the job market's bad. It's going to take them longer to get another job. And that's really what those entitlements are intended to help those employees with, how long it should take them to get another job. So where it's harder to get another job, the notice period's longer, your obligations as an employer are greater. Right. So that really is the kind of quick and dirty layoffs and terminations to make sure that I could hit those points for you. I am seeing a couple of questions pop up, so let me just take a look at those. And Jesse, thank you for letting me know that we're okay for a few more minutes here. So if you'd like to stick around with me, I'll stick around with you and answer some of your questions. So the first question I have here, the question is can I discuss reduced work weeks? I could take this a number of different ways. Please feel free to elaborate on what specifically you're interested in for your workplace. But broadly, what you should keep in mind as an employer is if you have employees who have full-time work weeks, generally full-time employees, and you can't give them full-time work right now when you're giving them reduced work weeks, 2 days a week, 3 days a week, even 4 days a week, you can offer that and they may appreciate it. But if you're making that decision unilaterally, and in most cases you will be making it unilaterally because employees don't usually want to work less than their usual hours and therefore earn less along with that. If you make those unilaterally, you can face constructive dismissal exposures because what you're doing there effectively is making a significant change to a fundamental term of employment. And that's really what constructive dismissal is, where the employer unilaterally makes a significant change, and certainly taking away 20, 40, 60% of the work and the compensation would be a significant change to a fundamental term. Obviously, comp and working hours are fundamental, really the most fundamental terms of employment. So that's something you want to be careful with. But at the same time, if you can provide that work, if your employees seem okay with it, they may not actually sue you for constructive dismissal. They may be happy to have that work and have some of their comp. And you just want to make sure that you understand where your employees are coming from and which employees might cause issues for you in those cases. So I have another question here. Oh, you know what? Before I get there, I thank you for clarifying that one for the individual who just asked that question. So the elaboration on that last question about reduced work weeks is that this individual read that COVID-19 impacts whether a reduced work week is considered constructive dismissal. And what that comes back to is that that rule that I talked about before about whether layoffs may amount to constructive dismissal right now or not. That's that same infectious disease emergency leave regulation that I was talking about that deems layoffs as leaves. It's actually not just layoffs that are deemed as leaves. I was just trying to get through it quickly. Where employees experience reduced hours or reduced wages right now, according to the Employment Standards Act, under this new regulation, they're going to be treated as being on a deemed leave, not on layoff. And so that's what that really means. And the other thing that regulation says is that those who are on these deemed leaves because of reduced hours or wages that are caused by COVID-19, they're not considered to be constructively dismissed. The dispute that I was talking about amongst lawyers that do what I do about whether that's the case more broadly is whether that regulation means that constructive dismissal is no longer constructive. These situations, reduced hours, reduced wages, layoffs, are not constructive dismissal only for the more narrow purposes of the Employment Standards Act, or if they're not constructive dismissal for the broader common law issue. I don't want to get into too much detail because there's a lot of fairly complicated legal concepts I would have to explain, but suffice to say that constructive dismissal is a concept in both under the Employment Standards Act and more broadly that affects the common law reasonable notice entitlements that I was talking about. And generally, there's an argument that certainly lawyers for employees who act on the other side of what I do, they're arguing that this regulation that says that these layoffs and reductions in hours and wages are not constructive dismissal, that's only for the purposes of the Employment Standards Act because the Ontario government can't change the common law unless they expressly do it. I don't want to get into too much detail there because what I can say is I may be arguing a different point if I'm facing cases like this in court over the next few months, and I'm sure that I will. But there is potentially merit to that argument. So there's quite a bit of uncertainty as to whether constructive dismissal, that general rule that significant reductions in hours or wages or layoffs without the right to lay off would be constructive dismissal. And so there is some uncertainty, there is some risk there. It's something that I'd recommend if you're worried about, especially if you think your employees might be getting restless, getting concerned about what you've done with their hours. You might want to get some advice and understand what kinds of liability you might be facing. So I have another question here. And so the question was, if an employee is laid off in March, the clock doesn't start to count for the 35 weeks until the end of the emergency leave in January. That's exactly right. So because those who were laid off going back to March have been deemed to be on infectious disease leaves during that time and not on layoff, those those maximum layoff durations permitted under the Employment Standards Act, again, 13 weeks or 30 or 35 if you keep on paying for their benefits, those aren't ticking right now because according to the Employment Standards Act, they're not actually on layoff right now, even though obviously, effectively, practically they are. Everybody understands they've been temporarily put off work by the employer. Colloquially, we call that a layoff, but technically under the Employment Standards Act right now, they're not on layoff and they won't be until after January 2nd when these temporary rules have changed or have expired. And then we go back to the regular rules where because the employee is off work, they're not working, they are on layoff, and then the 13 or 35 weeks starts to tick. Okay. During that whole time, by the way, just another point that's relevant, and I've had this question from a few clients recently, is whether if an employer has to let an employee go after they've been laid off or, again, deemed to be on leave for some time right now, whether those individuals, the period of the layoff counts for their service time when you're looking at their termination entitlements. And in most cases, yes, that service clock will be ticking. And so when the date that you actually tell them that you're letting them go permanently, that's generally going to be the end of their service for the purpose of calculating what they're entitled to at law. The one caveat to that is if an employee's actually on layoff, and again, no one's on layoff in Ontario, of course, as far as the ESA is concerned until January 3rd, but if they're on a true layoff under the ESA and the 13 or 35 weeks, whichever applies in the circumstances, expires and they're not called back, they're deemed to have been let go, then the deemed termination date for the purposes of their seniority and how much they're entitled to goes back to when the layoff began. But remember, again, under the ESA right now, no layoff is beginning until, no layoff that started in March or later is technically actually going to begin until January 3rd. So January 3rd would be the termination date for anybody who's laid off beyond that date and remains on layoff for the full 13 or 35 weeks without being called back. Okay, so I hope that's helpful. I'll stick around for just another moment here if there are any other questions. I know that we're getting over, and I think there's some other sessions that may be going right now as well. So I'll give it just a moment. In the meantime, again, just to loop back, there's lots more content about these topics and so many more that you can get from my firm's website, williamshrlaw.com, and I welcome you to go there and obtain that information.